So, ladies and gentlemen, welcome. Thank you very much for agreeing to take part in this remote consultation. We start the second part of this consultation. This morning we had a conversation with the Human Rights Commissioner, Mrs. Vladimir Gnatovskyy, and with Mr. Levizatos from the Venice Commission. And now we have about 45 minutes for you as a representatives of the major relevant monitoring bodies of the Council of Europe. I would like to remind you some technical nuances. When you are not speaking, it's better to switch off your microphone. As I see, everybody has done already. So, and now I give the floor to Mr. Vardanyan, who is the chair of the Subcommittee on Human Rights, who will introduce the speakers and will ask the first question. Please, Vladimir.
Once again, can you hear me? Okay, yes. Because I'm listening to echo. All of you for joining this initiative, joining this informal consultations. I would like just to represent our speakers. Mr. Mykola Gnatovskyy, the President of the Committee of the Prevention of Torture. Mr. Georg Stawa, a member of the European Committee for the Efficiency of Justice, and Ms. Alessandra Pierucci, Chairperson of the Convention 108 Consultative Committee. Once again, thank you for joining us, for being with us. And the first speaker I would like to address my questions is Mr. Gnatovskyy. Good morning, Mr. Gnatovskyy, or good evening. It's depend on the time when our viewers will see this video. Mr. Gnatovskyy, the CEPEJ was recently published a statement of principles relating to the treatment of persons deprived of their liberty. Our viewers, by the way, will find a link in the description below. Why did you think that it was necessary to publish this statement? But I'm so sorry, Mr. Gnatovskyy, would you be so kind to turn off your mic? Thank you.
Yes, thank you very much, Mr. Vardanyan, and thank you very much also, Mr. Cilevics, for your initiative of holding these consultations. It is excellent that we have this opportunity to exchange views. And I hope you can hear and see me now. To answering your question, Mr. Vardanyan, I would like to say that the reasons for publishing...
I'm sorry, Mr. Gnatovskyy, I'm not sure that we have your video, at least I haven't it.
Very strange, because it's on. Okay, can you see me now?
Now yes, now you're come back, so okay. Maybe you will start with the very beginning.
I will start with the beginning with pleasure. So I would like to thank, first of all, yourself, Mr. Vardanyan, and Mr. Cilevics for your excellent initiative of holding these consultations, because I think that it is an excellent opportunity for us to exchange views on the really very, very important and pressing issues. And thank you very much for your question concerning the statement of principles. I'm very glad that our viewers will be able to find it also below our video when it is published. And the reasons for publishing the statement of principles were, I would say, twofold. We did it a bit more than 1 month ago. And the first reason was that, of course, the COVID-19 pandemic has created extraordinary challenges for all member states of the Council of Europe. And clearly, every member state has an imperative to take firm action to combat the pandemic. And this also reflects the positive obligations stemming from the right to life, as envisaged by Article 2 of the European Convention on Human Rights. But it is also the key part of the duty of care, and the duty of care is owed by the state to all persons, the state deprived of their liberty. But there is another key part of this duty of care, and this is, of course, the absolute prohibition of torture and inhuman or degrading treatment. And this is why any protective measures that are taken by the state should never or must never result in any form of ill treatment of persons deprived of their liberty. And in this connection, it was obvious to our committee that the specific challenges faced by staff working in various places of deprivation of liberty are particularly intense. And therefore, our statement of principles is meant to be helpful for them in dealing with the pandemic efficiently while protecting the dignity of persons they care for. And secondly, since the very beginning of the pandemic, the CPT had received many requests for advice coming from the authorities of Council of Europe member states and from our peers at the national level, the national preventive mechanisms. And we felt that the voice of the Council of Europe was very much needed and eagerly awaited. And therefore we chose to come up rather quickly with just a one-pager containing 10 relatively simple and clear principles which are based on our expertise. And we are very glad that our statement of principles was endorsed by the Human Rights Commissioner and by the Secretary General of the Council of Europe in her toolkit for member states on respecting democracy, rule of law and human rights in the framework of the Covid-19 sanitary crisis. This is why I think we have managed to contribute to the joint voice of the Council of Europe in this area.
Thank you, Mr. Gnatovskyy. It's very important, in such dramatic times to keep the principles, and it's very good to have them very precise. Mr. Gnatovskyy, several countries have reduced their prison population by releasing some detainees. Is this something that CPT welcomes? What other measures should be taken to reduce the risk of infection for prisoners?
Thank you. The CPT very much welcomes measures that are aimed at reducing prison population and taken in the context of the COVID-19 crisis. It is a fact that close personal contact encourages the spread of the virus. And in many Council of Europe member states, penitentiary institutions make such dangerous close contact between prisoners inevitable. This is especially true when it comes to overcrowded establishments. I have often insisted that overcrowding is toxic and it turns prisons into human warehouses. But in the current situation, overcrowding can be deadly. And even for establishments which are not formally speaking overcrowded, the number of prisoners should be reduced. And this is also an important measure to contain the spread of coronavirus. We believe that concerted efforts should be made by all the relevant authorities to resort to various alternatives to deprivation of liberty. For example, greater use should be made, and I'm glad to say is being made in many Council of Europe member states, of alternatives to pre-trial detention, to commutation of sentences, to early release and probation. Altogether, these are measures that would benefit not just the prisoners, but the societies at large.
Thank you. It's very interesting point of view. Just a small follow-up question, if I'm allowed, for sure. What is the best way to declare amnesty, or what to do? Because when we are speaking about the prison population, we are speaking about the persons who are guilty in committing serious crimes.
Yes, indeed. First and foremost, the society must be protected. So we are talking about the reduction of prison population at the expense of persons who are not dangerous to the society. There should be an individual risk assessment of every such person. And therefore, the CPT, I must say, in general, has been rather reserved or even sometimes skeptical about measures such as amnesties, because amnesties are not individualized, and amnesties could be dangerous, and amnesties are not a long-lasting way of dealing with overcrowding, for example. But in this situation, perhaps it makes sense to consider amnesties, for example, for persons who committed non-violent crimes, who have only limited time left to serve their sentence, for example, less than 1 year or 1.5 years, as is being practiced, for example, now in countries like France or Italy. But in general, I think that once again, the measures should be as individualized as possible.
Thank you. And Mr. Gnatovskyy, the CPT does not just monitor conditions in prisons, but anywhere people may be deprived of their liberty. Apart from prisons, which places of deprivation of liberty give rise to the most concern? How should national authorities be minimizing the risk to people keep in such or in these places?
Well, certainly we are very concerned about all places that are within our mandate, not only prisons. And I'm sure all of us are very acutely aware that residents of social care homes are particularly vulnerable to the COVID-19 disease. And this is evidenced by a frightening number of deaths among them in the Council of Europe area. Also, psychiatric clinics in many countries still perform functions of social care homes because persons are kept there essentially for life. Of course, they are also very vulnerable, especially if they are of older age and also have other diseases to the virus. So additional measures should be taken also to reassess their situation and to find the way to treat them in the best way possible. We are also particularly worried about the situation of migrants who are kept in detention. In our statement of principles, and let me remind you that this was published on the 20th of March, we already expressed the view that the states should refrain to the maximum extent possible from detaining migrants. And in this respect, we also note an even more categorical position taken by the Human Rights Commissioner in her statement on the subject. Potentially overcrowded centers for migrants are really very explosive places. Like prisons, they can become amplifiers for the infection.
And the last question, Mr. Gnatovskyy, the restriction must also be affecting the work of the CPT and of national preventive mechanism which monitor detention conditions at the domestic level. How are you and your national counterparts adapting to the current situation, since everybody is restricted, even us?
Oh yes, that's very true. Thank you very much for the question. And this is essentially the huge part of my time recently is simply devoted just to this question. We nevertheless firmly believe that the monitoring by independent bodies, such as national preventive mechanisms, such as our committee, remains a very important safeguards against ill treatment. And all of us, the national preventive mechanisms, and of course the CPT, must keep our access to places of deprivation of liberty. And this also relates to the places where persons are held in quarantine. But new restrictions on the rights of detained persons also have been imposed recently due to the pandemic, and they contribute to the heightened tension in the places of deprivation of liberty. You have certainly seen reports of even prison riots in some Council of Europe member states, because when prisoners do not receive their visits or they are very severely restricted with their regime, then the situation can become really, really dangerous. Nevertheless, monitoring bodies should also adapt, as you said, to the crisis, and they should take every precaution to observe the do no harm principle. In particular, when dealing with persons at risk, with older persons, with persons with pre-existing medical conditions. And I know that several European national preventive mechanisms, including those from France, from Italy, from Ukraine, from the United Kingdom, have already taken concrete measures to adapt their working methods accordingly. And so they've continued to visit places of deprivation of liberty in their countries, but they also ensure that the detainees are protected during their visits, but also they want to make sure that the situation in the establishments and the measures taken by the authorities remain adequate. As regards the CPT, of course, we are severely restricted now by the European ban on travel. So we have a bit more time than the national preventive mechanisms who are already there in place. So we are taking this time to review our visiting program, to reprioritize very significantly, and also to elaborate the new methods for our visits. And I hope we will manage with this, and we will resume our work as soon as practicable. Thank you once again.
Thank you, Mr. Gnatovskyy, for joining us, for being with us and sharing with us this very important and valuable contribution. I would like to give floor to Chairman Cilevics, who will continue discussion.
Thank you. Yes, thank you, Vladimir. So I would like to ask some questions to Mrs. Pierucci. So, well, once again, welcome, Alessandra. You recently issued a joint statement with Mr. Walter, the Council of Europe Data Protection Commissioner, and we will add the link to this statement, to the description of the record of this video, of course. What do you think are now the main data protection concerns that have arisen during the pandemic? Is there a tension between protecting health, protecting privacy, and protecting, for example, freedom of movement?
Hello, and thank you very much, first of all, for giving the possibility to participate in this interesting event. If you allow me, I will start from your second question. I think that one of the most urgent needs which motivated the elaboration, together with Jean-Philippe Walter, of the joint statement you refer to, was, let's say, to clarify that although there may be the need to adjust to the correct balancing between different fundamental rights, we should not think in terms of conflict among human rights, but rather focus on their indivisibility and interdependence. There's an alarming public health situation which justified the introduction in many countries of specific regimes, and I come from a country, Italy, which was one of the most affected by the virus. And nevertheless, it should always be kept in mind that first of all, during emergency, limited period, the exercise of human rights as enshrined by the European Convention on Human Rights cannot be suspended, but only derogated or restricted by law to the extent that this is required by the exigencies of the situation, while always respect the essence of the fundamental rights and freedoms. Data protection should not be seen as an obstacle to saving lives. Its main principles, as enshrined by Convention 108 and its modernized version 108 Plus, already contains enough flexibility.
Seems you stopped.
Okay, can you hear me now? Yes, I was just saying that Convention 108 already.
Please.
Yes, okay. That Convention 108 already contains the flexibility enough to balance the different interests at stake. And just to give you an example, the monitoring of a life-threatening epidemic is explicitly mentioned by the explanatory report of 108 Plus among those interests for which the processing of personal data is legitimate, provided, of course, that the necessary safeguards are ensured. And now I would go to your first question. The main data protection regime, the data protection concerns we identified in the statement are, first of all, we are in emergency and measures should be kept as long as the emergency lasts. No temptation to keep restrictions when it is no longer needed. Second, the containment of the virus implies the processing of health-related data which are part of the special category of data, which under Article 6 of Convention 108 Plus enjoy a strengthened protection because of the potential discriminatory effect its misuse could lead to. Large-scale processing is another concern, as if on the one hand, artificial intelligence, big data algorithms are valuable tools in the fight against the pandemic, it is essential that transparency and explainability of these solutions are ensured, as well as a precautionary approach and a risk management strategy. We then consider data processing in the employment sector. We acknowledge the importance of the spread of teleworking, for example, in particular in this situation, but this practice, however, should not become the excuse for monitoring of employees. For us, it was actually the occasion to recall the principles stated in Recommendation 2015-15, which set forth the main principles to ensure workers' rights and their dignity in respect of the processing of personal data. And we also covered the development of surveillance tools based on location and proximity data, which must always first consider the impact on data subjects' rights, and that the least intrusive solution should always be preferred. And finally, e-learning, that with the closure of schools to avoid the spread of the virus exponentially increased. For us, it was very important to recall that data protection-oriented standard configurations should be preferred to ensure the right of the data subject, and I'm speaking about students but also teachers, and to avoid processing more data than necessary to achieve the legitimate purpose of ensuring educational continuity. So these were very concisely the main topics that we considered as data protection concerns in the peculiar situation of these days.
Thank you very much, Mrs. Pierucci. You mentioned monitoring, and this is exactly my next question about the so-called tracking caps, which many countries are developing or some have introduced already, in fact, to help limit the spread of coronavirus. How do these applications work in practice, and what are the data protection issues? Would it be acceptable for tracking caps to be compulsory, or for people to be allowed to do certain things or have access to certain places only if they have these applications? And what about people who do not have a smartphone at all due to some reason?
Yeah. Well, many national authorities and developers have announced the launch of apps offering different levels of functionality to support the fight against the virus. And among them, apps that support contact tracing have been considered as the most promising from a public health perspective. These apps are able to alert individuals that they have been in close proximity with a person who has been identified as being positive for COVID-19. The idea is that such apps, if used on a large scale so that they reach a certain percentage of the population, allow to rapidly detect contacts of cases and to inform contacts on the need for follow-up and testing if it requires. And moreover, the apps can also provide contacts of COVID-19 cases with information on how to decrease the risk of further transmission and provide advice on how to behave if they develop symptoms. So as you can imagine, being based on the processing of personal data, it is crucial that data protection safeguards are seriously considered in the deployment of these apps. And with Jean-Philippe Walter, we are working on a statement on this topic that should be available in the next few days, if not tomorrow. Let me try to highlight very concisely the main data protection standards we have to consider here. The effectiveness of digital contact tracing should first of all evaluated in the awareness that it depends on many factors. The elaboration of comprehensive national epidemiological strategy articulated in different tools, including testing policy, the architecture of the system used, the widespread access to mobile equipment and connection, and I'm going to what you were asking me before. The digital divide is an important element which should be duly considered in the assessment of the effectiveness of apps, which have to be, as I was saying before, part of a larger strategy and cannot become a source of panacea for all the problems. Trust and voluntariness of the use of apps is also very important, as correctly emphasized recently also by the European Data Protection Board. The systematic and large-scale monitoring of location and or contacts between natural persons is a very serious intrusion into their privacy. interference, to use the language of the European Convention on Human Rights. And it is crucial that individuals who decide not to or cannot use such applications should not suffer from any disadvantage. The effectiveness of these measures is really a question of trust, social acceptability, and responsibility more than compulsory use and repression. The need to define the purpose of the processing and to ensure transparency is also very important. This means that there must be a prior definition of the purpose of processing, and consequently that data are only used for that legitimate purpose and then deleted once the need is over. And also that clear information is to be given to data subjects to make them fully aware of the processing relating to them. That the source code should also be made public and available to be scrutinized by the authority and the public. Then risk assessment is very important as well. The development of these applications should be based on a prior assessment of the likely impact on fundamental rights prior to their deployment, and their design itself should be done to prevent or minimize the risk of interference with rights and fundamental freedoms. Data minimization is another key word. Contact tracing apps do not require tracking the location of individual users. So considering the particular nature of location data, proximity data should be used through Bluetooth rather than geolocalization. Digital contact tracing systems should be based on an architecture which relies as much as possible on the processing and storing of data on devices of the individual users. So several models of centralized, partially centralized, or decentralized architecture exist, but no one completely prevents from vulnerabilities and risks of re-identification. Data quality is also crucial, considering that the implications may be serious, self-isolation, testing, etc., for the individual identified as potential contact of someone infected. Ensuring the accuracy of data is crucial. The individual also retains the right not to be subject to automated decision, with a clear facility to challenge the consequences of such decisions, particularly in light of the inaccuracies which may occur in such systems. De-identification is also important. Users of the digital tracing system must not be directly identified, and digital contact tracing systems should only use unique and pseudonymous identifiers, cryptographically strong. And finally, independent oversight and audits to ensure respect of the right to privacy and data protection is also needed. In this respect, data protection authorities play a crucial role and should be involved from the outset in the development of those systems. So I hope that I gave you, although concisely and not exhaustively, an overview of the main data protection principles to be considered in the introduction and deployment of these apps.
Thank you very much for this very detailed and very clear answer. And actually, you preempted my next questions about how people can be encouraged and reassured to use these apps. And I believe the principles you mentioned indeed might be effective, although it will not be easy. And my last short question is, how is it possible to ensure that the same technologies are not kept in use for other, less justified purposes once the pandemic is over?
Mm-hmm. Yes. Well, again, as I said before, apps are a possible tools of what should be a much more complex strategy. And what I wanted to add in respect of the beginning of your question is that what do we do with the results of these apps if we are not in a position to properly react and take the appropriate measures such as testing? The risk often perceived in the last decades, I would say, by the data protection community is the trend sometimes to delegate to technology systematically and uncritically the resolution of complex problems, whose solving can be, of course, facilitated by the use of technological tools, whose effectiveness and impact on fundamental rights must, however, preliminarily always assessed. Only in the presence of a serious assessment of the real need of new tools, on the possible recourse to less intrusive measures, on the impact of intended measures on human rights, and in full transparency for people involved, the necessary trust will be developed and people would be encouraged to use such new tools. Just let me mention one more thing. Professor Harari, in an article which appeared on the Financial Times some weeks ago, you may have read already, reminded us that a self-motivated and well-informed population is usually far more powerful and effective than a policed and, let's say, ignorant population. And he uses an example, I think, very actual these times, considered as one of the greatest advances in human hygiene, washing your hands with soap. You recall that this is an action whose importance has been discovered only recently in the 19th century, and he concludes that today billions of people daily wash their hands, not because they are afraid of repression, but rather because they understand the fact that viruses and bacteria can be defeated by hygiene. In order to develop responsible behaviors, we need trust. That's what I wanted to give you as my last message, and awareness and the reassurance also, and I'm going back to your last question, that the personal data collected will never be used for further processes, such as commercial or law enforcement, for example, and that the measures adopted in exceptional times will not be prolonged, getting the status of ordinary measures. In respect of further uses, the deletion of data I referred to before is a very, if you want, basic measure to prevent the temptation of reuse of data for additional purposes. As the risk that new urgencies will always justify the prolongment of extraordinary measures, it is our responsibility, I believe, to foresee from the very beginning concrete measures and procedures regarding the return to normal data processing regimes. Thank you.
Thank you very much, Mrs. Pierucci, and we very much look forward to see the new document prepared by you, you mentioned, and certainly we will try to rely on it to publicize it also, just like other relevant documents. Thank you very much, and I give the floor back to Mr. Vardanyan.
Pierucci, on my behalf, I would like also to express the words of gratitude to you, and I would like once again to welcome Mr. Georg Stawa, member of the European Committee for the Efficiency of Justice. Hello, Mr. Stawa, and I would like just to ask my first question. Mr. Stawa, I see that CEPEJ is gathering information on what Council of Europe member states are doing to adapt their judicial systems to the pandemic. What are the main tendencies that have been revealed so far? Are there good practices respectful for fair trial rights that could be followed more widely?
Thanks. So, first of all, to give me the floor, and thanks for the invitation. This is highly appreciated, as definitely it is the right time immediately to talk and discuss about this. And in regard of your question, I may remind ourselves, even as my pre-speakers, from their perspective, that first of all, we are confronted with a health crisis. So this is not a crisis of rule of law or the crisis of democratic institutions, which means also accordingly that the cornerstones of any kind of democratic constitutional state must remain stable during the crisis. Rule of law is not on sick leave, is the sentence we should keep in mind, and therefore its protection must continue. The crisis also must not become an excuse for any kind of deficits and shortcomings. This is maybe some kind of the most popular sentences we will get known in the next month, that someone is trying to blame the crisis for everything, including also some kind of deficits in democracy and rule of law application and whatever you can imagine. Please stop that. Make us not allow this becoming some kind of mantra-style thing, blaming the virus for what it is not to be blamed on. This would be even a little bit unfair in regard of the virus. He is powerful. The virus is powerful, but not that powerful that it will abolish rule of law in our beautiful continent. That's for sure. And also what I'm most concerned and what is also not visible on first hand is that we all have to have a clear focus on that the so-called crisis and all the special measures we have to apply now in our systems in all the different perspectives must come to a clear end sometimes. I think the sentences like, oh, the second, third, or fourth wave will come, or we are still fighting the effects of the crisis, is the more dangerous sentences than any kind of effects we can see on medical level right now, because the medical effects will, of course, be handled by the time, and we will learn to do that. But if politicians are getting used to keep us in that kind of crisis mode, a lot of things are possible which should not be, and we may also get used to some kind of limits of our fundamental rights and freedom, or some kind of shortcomings we accept for the duration of the crisis in judiciary. So let's keep that in mind. It is a health crisis. It is to apply some kind of technical measures to come over it, but it is not something we should get used to on the long term of making it an excuse to reduce our standards we have developed for the last 300 years since we started to fight in France against the kings, the dictators, and everybody who was not able to give us the personal freedom we are used in modern Europe. So this is something we have to keep in mind in general. Of course, every kind of solution we apply should therefore also not be misused to reduce these kind of standards, even if it is very tempting for some politicians, as it is of course attractive also to sell it a little bit like this. And speaking about the risks, I may also put a headline on the other side of the spectrum that the crisis creates a lot of opportunities, especially in judiciary, to come over some obstacles we also got used to and discussed for a very long time. It may be a good opportunity to introduce new tools. About video judge, we may talk then in an extra paragraph, so to say. A lot of that kind of tools to improve judiciary were heavily discussed, and of course as they are very sensitive, not introduced immediately, but a lot of these kind of tools are aware, we are aware of these tools, and they are, let's say, available if we want to apply. And you could see in the crisis that with for example, the video judge, yes, it's sensitive, but it is a way to provide justice. I will talk about this a little bit in 2-3 minutes. So it is interesting to make use of the opportunities to come up with new solutions, and by this also to improve the procedural efficiency, judicial administration, even data protection and productivity. To conclude your question in regard of the Commission for the Efficiency of Justice, is that we are known as that kind of think tank who is dealing with improving the efficiency, having an eye on the balance between productivity and quality of justice, and looking for new models to improve providing judiciary. We started, of course, with collecting information and having set up some kind of best practices applied in the member states fighting the situation. There is no general trend where you can, there is a general trend in this short time technical measures, like everybody is shutting down the courts to the minimum. Everybody tries to avoid judges working in the courthouse at the moment. Judges should work at home. By the way, in some countries, I don't mention the name, they came up with the shorthand conclusion that judges at home in second instance are more productive than working in the courthouse. So even something which is not expected, but you see even after 3 weeks, a country was able to identify this in the statistics that, okay, maybe it's a better idea to let them work at home, and they should meet once a week for their panel discussions in the courts, but otherwise think about the problem by themselves. Of course, there is limitations at the moment in the court hearings. Most of the countries have locked down the activities in the way that they focus only on the most urgent and most important hearings, like domestic violence, caretaking, immediate caretaking of children, most important criminal trials if necessary, but very much reduced, and start now to reopen the court's activities in the next months with special protection measures, and also with the use of as much as technology as possible.
Mr. Stawa, thank you. You already touched upon some aspects of my second question because you addressed the issue of using the new tools. I imagine that in many courts now we are using video conferencing tools to conduct virtual hearings as a way of making progress with the cases while still avoiding gathering. Do you have more detailed information on this or on the other alternative? Do you see any risk of such procedure?
Yes, of course. I mean, we have experienced it here within this last half an hour as well, that of course the video technology, if you provide it on some plain basics like we are here using, is having the risk of, I don't know, bad connection interrupted. We can't see what is happening behind the cameras, if someone is standing with a loaded gun and forcing you to say something, etc., etc. So these plain risks are aware, and that's also the reason why video technology and the use of video technology was promoted in the past only in very closed content. So if you're working in a closed network, if you're working from court to court, if you have a witness coming to the court and then being video recorded and connected, or if you have a detainee in a prison and he's able to speak with his defendant, then yes, but otherwise being careful. Nothing has changed on this kind of arguments on the pros and cons, but what is an argument is that even in Corona times or in times where we try to lock down social contacts and court activities, it is to provide justice. The famous decision of the Courts of Human Rights that justice delayed is justice denied. And a lot of European countries still have problems with backlogs reduction, with coping with the amount of their workload. So it is always an important focus on the fact, get rid of the workload or find political, legal constructions that the courts are not overloaded and social disputes are sorted out by something else. And you mentioned the video video court solution. This may work, for example, if we think of civil disputes where we talk about a quick session with 2 lawyers and maybe an expert, which are these technical sessions. Therefore, I think it is totally fine. In a context where we are talking now, we wouldn't have a problem to discuss the technical issues of a proceedings, for example, or to have this kind of 15 minutes typical short sessions. We would even start to like it and love it. And the first thing which we have heard from the private lawyers is that, of course, now the private lawyers are also missing their business. Even if the private lawyers are the most critical ones if it comes on introduction of video court systems, because of the concerns and also because of losing a little bit their show. to the clients. It is now them to promote it a little bit because it is enabling them invoicing some business, to make it clear, and also to keep the trials running. So I guess the market here will meet on low-level technical meetings. We will get used to doing this on video. And if it comes on sensitive issues, if it comes on criminal matters, if it comes on more complex stories, of course we will meet in the courtroom, protected a little bit more than we have been in the past, and providing something which is more the classical solution in front of the court. But if we go beyond, it is also the time to really think of new ways how justice should be delivered. If you think about online dispute resolution, if you think about other mechanisms, artificial intelligence combined with internet could provide in the frame of rule of law, I think this is the time frame now where we should intensively focus on and discuss under what circumstances this should be provided by the public. I'm just reminding you that eBay with their online dispute resolution system is sorting out more than 60 million cases a year. You know, this is bigger than any kind of national judiciary is doing, but this is cases which otherwise would end up in front of a judge in old school times. And I think that we should focus on what kind of disputes in modern times, 2020 and upcoming, are able to be handled by such kind of platforms, maybe hosted by a European institution, by a national judiciary giving you the stamp and seal for whatever you found out there. And by this way also preventing that judicial systems are clogged by unnecessary workload.
Thank you, Mr. Stawa. And the last question, but not the least, judicial process has become as much more scarce resource. How should judicial system prioritize their activities given the restriction caused by the lockdown conditions?
This is, I think, a question which is answered more or less by nature. Of course, you have the most important, most sensitive issues which have to be dealt in front of the court, or which have to be dealt very urgently. Domestic violence is definitely an upcoming issue if you lock down people at home. So any kind of these cases have to be dealt immediately. If it is done by video or online dispute resolution or the court's activity in classics, doesn't matter, but it is clear that there must be an immediate answer on that. Criminal cases where you keep people in custody as well have to be addressed immediately. You can't wait 3 months, 4 months, maybe even a year after we come back to some more normal before you come up with hearings and apply the procedural rights to a detainee. So these kind of examples are typical for what has to be prioritized, and where every court system, judicial system, has to focus on to provide justice on these kind of priority measures. Everything else, at the moment, most of the countries allow to delay, but as I said before, this is very dangerous, because you just have to imagine if you delay court hearings for only 3 months, means you increase your backlog by 25%. And if you do this 4 years, then you have the full workload of a full year in front of you. So this is not acceptable. So we have maybe 2 months, 3 months, maybe to find new solutions, but this time is passing very quickly. And it will be very interesting to see how judicial systems are able to react, to monitor this, and in cooperation with the judges and other European judicial institutions find ways on technical level to improve the functionality of courts immediately again. This is also where the Council of Europe is popping in, and where Council of Europe has a long tradition of giving feedback and also supporting the member states in best manner.
Mr. Stawa, thank you so much. I would like just to wrap up all the discussion. I would like once again mention that we had as our speakers Mr. Mykola Gnatovskyy, Ms. Alessandra Pierucci, and Mr. Georg Stawa. and we addressed the issues of the impact of COVID-19 on the human rights and rule of law. And I totally agree with you that rule of law is not on a sick leave during the crisis. I totally agree with our other participants saying that it's better to educate than to prosecute, or it's better to explain than to punish. And I would like just to say that, yes, for sure, we should consider this crisis also as an opportunity of being more efficient, of looking for the new tools for better protection of human rights, for better understanding what is the data protection and how it is working in the reality.